All right, there's really no established.
You have one more.
Yes.
You have one more. There's one more.
Sir, can you see me?
I can, yes.
My name is Martin Shelby. I'm the Tampa City Council Attorney, and I'm here as just an observer. I would have to be watching this eventually anyway, and I was wanted to see this as it happened.
Yes, sir. Thank you, Mr.
If there's any objection for my being present, please, somebody bring it to my attention.
There do not appear to be any objections. Welcome, Mr. Shelby.
Thank you, sir.
The code doesn't really have a strict procedural guideline for this type of proceeding on a remand. So what I'm going to do is first start off with the city attorney's office, if I may. And Attorney Johnson Velez, do you have any evidence you'd like to present at this time?
We do. It is the string, the email string that we submitted via email to you, as well as all other parties who I think were in the room by email on Friday.
Thank you. Yes, I reviewed that, and because there were no objections to any of the submittals, everything that was submitted will be in evidence.
Okay, thank you. And so I just have a few questions that I would like to ask Mr. Cotton.
Please proceed.
I'm sorry, if you could just swear in all the witnesses
Oh, yes.
present.
Thank you. Do you swear or affirm to tell the whole truth and nothing but the truth?
Yes.
All right, let the record reflect everyone indicated in the affirmative. And please proceed, Attorney Johnson Velez.
Okay, thank you, sir. Mr. Cotton, when did you receive the March 8th, 2000 letter that we referred to this morning?
I originally received that on April 12th, 2021.
And who did you receive the letter from?
It came from Jason McCarty.
Okay. And was the March 8th, 2000 letter included in the application for formal decision that was eventually numbered FDN 21-125?
No, ma'am.
Okay. And so when you issued the original letter on August 17th, you did not take that letter into consideration?
That is correct.
Okay. And what happened subsequent to that letter, to you issuing that August 17th letter, after you issued that letter? Did you come to recall that you
It was
had
pointed out.
the March 8th, 2000 letter?
It was pointed out to me by a member of the city's legal department that the letter had been received prior to the application being submitted. I just did not recall that I had received it, so therefore I didn't look at it when I was writing the original letter.
Okay, and so once the letter, you were reminded of the existence of that letter and that you had previously received it by the legal department, what did you do at that time?
There was discussion internally, and it was determined that the letter was valid, and based on that letter that was originally received April 12th, a new letter was issued by the city, or by me.
Okay, and then is that part of, well, let me hand you. So it was not, you did not receive that letter as part of the open record period?
That is correct.
Okay, but you had it prior to the open record period even commencing?
Correct.
For this FDN application? Okay. And did you also do I guess we'll call it a forensic examination of the city's files for the area rezoning in 2000?
I reviewed
This letter
the complete file that was provided by the city clerk's office, yes.
Okay, and did you find anything in those files that, well, did you find the March 8th, 2000 letter in those files?
No, ma'am.
Did you find any indication or any evidence of the existence of the March 8th, 2000 letter in those files?
No, ma'am.
Okay. I don't have anything further, but I would like to reserve the opportunity to further question Mr. Cotton if it becomes necessary.
Understood. Is there any cross-examination from the petitioner, Mr. Caldwell? None. The property owners council?
No, I'm not an attorney.
Okay, I apologize. And Steve Michelini, is that correct?
Yes, sir.
Okay. All right, seeing no cross-examination, do you have any other witnesses you'd like to present at this time?
No, not at this time, sir. Thank you.
Thank you.
Matt,
Mr.
could I add a comment here? I think there was a misunderstanding. I prepared an affidavit regarding my testimony. It's a written and notarized affidavit.
Yes.
When it's my opportunity to speak, I can read that into the record since we didn't submit that to you in advance.
If you have any testimony to present, please present it at this time.
We can't object to that. This should have been submitted by last week at Friday at 5 o'clock.
He's permitted to testify live, and you have the right to cross-examine.
I'll read this into the record. I provided the city attorney with a hard copy of this, which we can forward to you as well. I'm Stephen Michelini.
I won't consider the affidavit. I will consider your testimony, though.
I'm Stephen Michelini, over the age of 18, and with personal knowledge of the facts set forth herein, and state that I am the owner and operator of Michelini Consulting, which is established governmental relations consultant, where I assist individuals and corporations in regulatory affairs. I've been in the business since 1987, and I'm certified as an expert on governmental issues, including land use and zoning, with the 13th Judicial Circuit Court. Prior to my starting Michelini Consulting, I've been engaged professionally in these matters since 1976, either as a governmental employee, a private consultant, or as a witness. I have over 45 years of governmental relations consulting, land use, zoning, and representing clients in various economic development and development activities experience. I confirm that on or about March 2000, I was hired by 717 Parking and related issues and entities, including Ebor Properties LLC, 717, to handle the matters of zoning and land use changes for the properties located at 1916 and 1918 East 5th Avenue, Tampa, Florida 33605, Ybor City, folio numbers 189915.0000 and 189916.0000. Herein referred to as the property and other properties within Ybor City District managed and owned by 717 and related entities of the neighboring properties. To my knowledge, and for over 30 years, the property has been approved to operate as a surface parking lot for the previous and current owners under the previous YC6 zoning, and was established as an allowable principal use of parking on this property. On March 16th, 2021, my client was issued a notice of violation of current YC7 zoning, and per section 27-177, principal use parking is not permitted use. It issued violation. Since my client was operating the property as a legally established principal use parking prior to the violation, we checked with the zoning department and found that the city of Tampa updated the current zoning of the property from YC6 to YC7. We've conducted an in-depth research and evaluated multiple private and public document records. The property has been approved for use as a principal use of parking since 1980s. The property was purchased by Chris Kirshner in February of 1995. Mr. Kirshner self-managed the property for surface lot parking under the principal use of YC6 zoning, as described herein in the letter. The property was a legal non-conforming principal use parking lot prior to the city rezoning the property from YC6 to YC7 in the early 2000s. In addition, my client reached out to the city land development office, inquiring about the change of zoning of their affected properties within the Ybor City District, and referred to and had a conversation with Gloria Moreta, the manager of land development coordination at the city. At my client's request, I met in person with Gloria Moreta on 2 occasions to discuss the proposed zoning and land use changes. Gloria Moreta confirmed that my client could opt out of the zoning change from YC6 to YC7 by sending her a letter requesting the city of Tampa not to change the current land use from YC6 to YC7. zoning for the property and any neighboring properties in the district. These opt-out letters were submitted to Gloria Moreta on March 8, 2000, on behalf of my client of 717 as described in the attached letters. See attached exhibit. Anyway, my client was not aware the city of Tampa decided to proceed with the zoning in early 2000 to YC7, even though they were complied with Gloria Moreta's request to remain YC6. The city did grant the request for the neighboring properties not to change the current zoning from YC6 to YC7 for several other 717 properties and related entities and properties in the Ybor City District. My client and I were unaware of why the city did not include the client's request for this specific property, which my client and I believe was rezoned and not included as an oversight, an error, and an omission as all other properties that were submitted at the same time. And the parking lots were granted to stay in the YC6 zoning and continue to operate as public paid parking lots. Further, I see nothing. Stephen Michelini is sworn before a notary.
Mr. Michelini, do you have any other testimony to present?
The only thing, in summary, is that we timely filed the letter requesting to opt out. We support the city of Tampa's position that we did that in a timely manner, and it should have been included in the area-wide rezoning to remain as YC6.
Does the city have any cross-examination on any of the testimony presented by Mr. Michelini?
Yes, I would. Just for a point of clarification, who submitted the letter to the city?
I
In
did.
2000. You submitted the letter.
I hand carried it to Gloria Moreta and delivered it to her office.
Okay, and do you have any knowledge of what Gloria did with it after you submitted it to her?
While I was in her office, she put it in a stack of papers with other property owner requests to be opted out.
Nothing further.
Does the petitioner have any questions?
Yeah, I don't understand why none of this was brought up before. You never brought this up before in our last hearing. All this
Sir,
information.
Sir, if you could ask a question, if you have.
Why wasn't this brought up in the last hearing
Thank you.
that we had here? All this information and you're
I testified to this before.
not to this detail at all.
Well, in consultation with my client, we believe that it was prudent to prepare an affidavit that outlined exactly what happened. And so that's what we did.
You have any further questions, Mr. Codwell?
No,
All right, thank you. So does the property owner have any additional evidence or witnesses at this time?
I support Mr. Michelini. I myself, under oath, spoke with Gloria Moreta. Fortunately for us, we were able to find all the letters, provide the documentation to the city as requested. Again, this has been an operating parking lot for, I don't know, over 30 years. So this is not a parking lot issue as much as it is a zoning issue. The zoning was changed from YC6 to YC7 without anybody notifying us. We continue to peacefully operate our parking business in the area. And out of the blue, we got a citation from the city for a zoning issue. And so the minute we got that, we contacted the city and followed what they asked us to follow. And luckily, we were able to find the letters and any support we had during that time frame and provide it to the city. And we support their decision to grant us YC6 back zoning that should have been from day one. And I respect you guys as neighbors. I have no issues with that, but they changed my zoning without us being notified or anything. And we found out about it over 20 years later. So I'm not sure what you would do if you were me, but that's up to me.
Does the city have any questions for Mr. Arcadia?
No.
And sir, could you pronounce your name again? I want to get it phonetically correct.
My name?
Yes.
Jason Accardi, Accardi.
Accardi. Mr. Cadwell, do you have any questions?
Yes, I do. Mr. Cardy, do you said you've used as a parking lot for 20 something years. Do you have any receipts or anything that could prove that you've been using it as a parking lot for the last 22 years?
Do I have receipts? I'm sure we do.
Other than your testimony.
Yeah, I mean, again, I believe this is a zoning issue more than a parking lot. I mean, the long-term use of this is not to keep it a parking lot, just like all other properties we have in Ybor and other areas. I mean, we're in development at some point, but again, this is a zoning issue, because of the permitted use under that zoning for parking is restricted. Is it Joe, right?
Yes, it shows.
Yeah, so under YC7, the reason why we opt out, just to be very clear on all of our properties in the area, is because the zoning didn't allow for a permitted use for parking. And since it was grandfathered in before, Steve met with them and we asked the city to opt out because we were allowed to do that. There was, the only one that's sitting here today, with all due respect, is Mr. Bailey, who I'm not sure if you were in those public meetings that I was with the whole group, the YCDC, and maybe that's part of back then, but they had plenty of public meetings. They told us what to do. I hired a professional to go and opt us out. It was missed, but the parking has been continuous for a very long time. If we park one car there a day, or if it stays vacant for a little bit, it is used for parking lot.
Wasn't there a letter back in 2007 that mentioned there was an issue with this zoning back in 07 that this should have been resolved back then? I believe that was submitted under Mr. Michelini, or the Cardi submitted that in 07
I'm not sure what you're referring to. I have no idea.
to Catherine Cora. Yeah, it was submitted to Catherine Cora.
If there was the original.
It's part of the original information.
I think it's in this. Well, I don't know.
Mr. Cowell, do you have any additional questions?
Mhm. Do you know who the owner was of March 8 of 2000 of this particular lot?
I don't have those documents in front of me. I mean,
You don't know if you were the owner of March 8, 2000?
without looking up a public record and seeing we bought the property, I'm not sure. March what?
March of 8, 2000, when this letter.
At the time, Chris Kirchner was the owner of that property, and we were the agent for them, pursuant to the letter that was submitted.
The letter doesn't say you're the agent for them at all. I'm going off memory here, but it doesn't mention that at all. Can we read the letter?
I mean, you can read the letter if you want.
Mr. Caldwell, before you do that, do you have any other questions? You'll have an opportunity to present your evidence.
No. Any other question?
No further questions. All right. Thank you, sir. Mr.
I'm
Caldwell,
sorry.
do you have?
Oh,
Yes.
I'm sorry, Mr. Schroff, could I just ask Mr. Cotton a question? I think it'll put it in the right context at this point before the petitioner. Just
Is there?
about the
Sure.
opt-out letter itself.
Sure. Well, one moment. Is there any objection to the city presenting additional evidence at this time? All right. Seeing none, go ahead. Thank you.
Mr. Cotton, just for clarification, what is your understanding of the city or the city policy with respect to opt-out letters of the nature of the March 8th, 2000 letter in this area-wide rezoning in 2000?
Historically, my understanding was property owners were given the opportunity to opt out of a zoning change or a land use change by policy. And they could present evidence or documentation saying we do not want to be part of this rezoning, and council will leave them out of that rezoning.
Okay, all right. Thank you. I have nothing further.
Understood. Thank you. Any cross-examination from either the property owner or the petitioner?
No.
As to Mr. Cotton's statement,
I have a question for Mr. Cotton.
please proceed.
Eric, is this the letter that you received regarding this opting out provision?
That's the letter that I received as part of that email from April 12th.
And that letter certified that the property owner did wish to be opted out from the zoning change?
Yes, that request is to be left out of that zoning change.
Thank you.
Mr. Caldwell, do you have any questions for Mr. Cotton on that issue?
Yes.
Can
Can I ask
Can
a
Stephanie
question?
ask a question on my behalf?
No, unless she's your lawyer of record, no.
Okay.
But Mr. Michelini is not the lawyer of record either.
He's identified as the agent in these proceedings. You'll have ma'am, you'll have an opportunity to speak. All right, so Mr. Cadwell, do you have any testimony you'd like to provide or witnesses at this time?
Yes, I'm going to provide a testimony, and then these are 3 witnesses that would also like to speak on behalf Chris Curry, Stephanie Bailey, and David Bailey.
Understood. Thank you. Please proceed, sir.
So the main reason we're here, of course, is the main exception that we're taking is this letter and when it was produced. We clearly understand what happened in early 2000 and that you could object and keep your old zoning. The main reason we're here is this letter was not in the city. It's in no city records. And it was provided by Mr. Carty to their testimony, emailed over to Eric Cotton or dropped off to Gloria Moreta, is what you said today. All their other lots, they have proof of, I'm sure, within the city. They got all their zoning. This one was not there because, first of all, it was never emailed over. It was never mailed in. And they also didn't own the property at the time. So that's probably why it was never mailed in. I believe they know what they're doing. They've been in business a long time. And I just feel like we're 22 years later, and they're just trying to pass this over like an oversight. And it's really not. So that's all I have to say really on the matter. And I'd like to pass on to Chris Curry.
Thank you. Before you do that, sir, does the city have any questions for the petitioner?
No questions at this time.
And does the property owner have any questions?
No, sir.
All right, Mr. Curry, please.
Thank you, Special Magistrate. So regarding the request by City Council about the chain of custody, I'd like to present some information. Talk about the letter in question, and for clarity, this letter that was dated March 8th, 2000 is the one that was referred to by the zoning administrator, Eric Cotton, in his 8/30/21 determination letter. And what he states is that additional documentation was discovered by the city relevant to the determination regarding the property's land use and zoning. As a result, the zoning administrator rescinds the letter dated August 17th and issues the following determination letter regarding the subject property. So this letter specifically is the only piece of additional documentation in the zoning administrator's rescission of that letter. For the record, this was sent in by Jason Accardi, and it was only entered into the public record 21 years after it was allegedly written on 8/17/2021. Through records requests and confirmed by the city attorney, Andrea Zellman, the first time the city received this opt-out letter written by Jason Accardi was on 4/12/2021 when he emailed it to Eric Cotton. The letter was actually sent to Eric Cotton as a result of an ongoing code enforcement case, case number CMP 20-0009892, and had nothing whatsoever to do with formal decision 21-125 because this matter did not exist at the time. This 3/8/2000 opt-out letter was also sent directly to former city attorney Gina Grimes, as well as Deputy City Attorney Andrea Zellman, directly by Jason Accardi, roughly during the same time frame. The first time that the 3/8/2000 opt-out letter has any official attachment to FDN 21-125 is when it was uploaded to the Acela system on 8/17/2021, 13:38 hours by the zoning administrator Eric Cotton. This upload occurred after the initial determination letter by the zoning administrator Eric Cotton for FDN 21-125, dated 8/17, was emailed out by Eric Cotton, where he states, "There's no direct evidence to support the statement that these two properties were requested to opt out of zoning and land use zoning changes. Additionally, in reviewing the evidence submitted as part of the application, there's no evidence that the two properties were being utilized for parking prior to the issuance of the notice of violation. As a result, the formal decision is denied." So this Acela entry on 8/30 by Mr. Cotton also states that the upload is updated to reflect documentation not included by the applicant in the initial Acela application. Just to reference code section 2754, process for application and written determination as formal decisions. Section B7 states the zoning administrator shall consider all documentation received as part of the application through the open records period. also states in C2 that the open record period shall conclude 15 calendar days after the date that the mailed notification is postmarked. And then C3, it says, at the conclusion of the open record period, the zoning administrator shall not accept for consideration any additional information. So for the record, the open record period on FDN 21-125 was from 7/9/21 to 7/24/21. And the only time that this letter is officially attached is on 8/30, when it, or sorry, 8/17 rather, when it was uploaded to the Acela system. For the record, also wanted to point out some additional code. Section 2153, written determinations by the zoning administrator or applicable code authority as set forth in this chapter. C1 says, under no circumstances is the zoning administrator permitted to grant exceptions to the actual meaning of any clause, standard, or regulation contained in this chapter to any person. C2 says the zoning administrator is not permitted to make changes to this chapter or vary the terms of this chapter in carrying out their duties. And C3 says interpretation shall not be given to any person solely based on hypothetical facts. So regarding the chain of custody, the letter was emailed in by Mr. Riccardi to the zoning administrator on 4/12, not part of case 21-125. The open record period concluded on 7/24. The FDN, the initial FDN was emailed out by Eric Cotton on 8/17. The 3/8 opt-out letter was uploaded to the Acela system on 8/17 and uploaded to who states updated to reflect documentation not included by applicant. So in summary, regarding this point, this letter was not submitted for consideration in the written request for formal decision or during the open record period. It should not be given consideration or be considered valid per code 2754. The zoning administrator did not possess the authority to grant an exception or allow this letter to be considered based on a hypothetical fact that it was submitted in 2000 per code 2753. Regarding the second part of City Council's request was to obtain evidence of other applications. I have a couple points on that. In the initial application for formal decision, Jason Riccardi submitted 2 opt-out letters dated 3/8/2000 that were submitted to the city as supporting evidence. And I have Exhibit J is where that's referenced. In these letters, which I submitted to you, Exhibit K and L, they're identical in every way, other than the folio information and the addresses. So when you look at those side by side compared to the letter in question, all 3 letters were allegedly written by Jason Riccardi on 3/8/2000. The first 2 letters, which were actually submitted into the city of Tampa, are identical other than the folio information and address. And then the third letter, the letter to the right, was emailed to the city in 2021, and it's highlighted to show the many differences compared to the other letters that were on record. In Exhibit K, which is actually property that was owned by Jason Riccardi or 717 Parking, the property addresses were 1612, 1614, and 1616 East 5th Avenue. And the city of Tampa did in fact confirm that these properties were excluded from proposed zoning changes, and the documentation that these were excluded, I've included also as Exhibit N, O, and P. No other properties, especially not the properties in question today, have any documented proof of opt-out of zoning approval. So we know that the city did have a method for recording information, and it was excluded. And at some point, it's the responsibility of the property owner to follow up if that wasn't excluded, if they didn't receive that excluded information, and not how would the city know that they didn't receive that information? How would the city know that something wasn't excluded? And on 3/8/2000, neither Jason Riccardi, 717 Parking, or Ebor Properties owned either of those. They were owned by Gary and Karen Kirshner. They owned 1916 East 5th. Chris Kirshner owned 1918 East 5th. These properties were sold by the Kirshners on 9/28 to Ebor Properties or Jason Riccardi over 6 months later. Only Gary and Karen or Chris Kirshner had the legal ability to opt out of zoning changes for these properties at that time. Only Chris Kirshner was CC'd on the opt-out letter, which was brought up previously, saying that all the owners were aware of the zoning changes and opted in. So Gary and Karen Kirshner were never CC'd on these. There is no agent affidavit on file to back up the 3/8/2000 opt-out letter. And this letter is in no way proof that the Kirshners were aware or in agreement of the zoning changes. Many idiosyncrasies exist with the 3/8/2000 opt-out letter that was considered additional documentation on 8/3/2021. Its lack of chain of custody for 21 years preceding 2021. There is no proof that it was excluded, like the excluded letters, the other properties, other than the word of the property owner and the testimony by Mr. Michelini. And there are glaring abnormalities in the structure and content of the letter itself compared to the other letters that were actually submitted by the same person at the same time 20 years ago. It should not be given consideration and should not be considered valid. Thank you.
Thank you, Mr. Curry. Are there any questions of Mr. Curry from either the property owner or the city?
I don't know.
Yes, the city, I just have one question. Sir, do you have a copy of code section 27-54? I think you referred to it in your testimony. Okay. If I could ask you just to refer to subsection B7.
Okay.
Just with regard to all of the things that section mandates the code administrator, the zoning administrator consider in evaluating a formal decision request. So can I just ask you to read that first sentence?
The zoning administrator shall consider all written documentation received as part of the application and through the open record period, and any other relevant information obtained through research conducted by the zoning administrator or designee. In addition, the zoning administrator shall have the authority to review and evaluate the request in light of the comprehensive plan and other, the official zoning atlas, other statutes, codes, ordinances, whichever applicable, and to consult with appropriate city staff and legal department if so desired.
Okay, so based on that, is it your understanding that the zoning administrator, in addition to documents received as part of the application and during the open record period, can consider other relevant information that the zoning administrator might have?
Oh, I'm not sure. I'm not an attorney. And,
I was just asking,
I'm not
based on what you just read, any other relevant information obtained through research conducted by the zoning administrator? What do you understand that to mean?
exactly what it says.
Okay, so other information besides what is obtained during the open record period?
Well, that's what it says. Yeah.
Okay, and then also to the end of that second sentence there, in terms of what the authority the zoning administrator has, just the very last sentence after that last comma, the zoning administrator is authorized to consult with appropriate city staff and the legal department if he so chooses. Is that
Well,
correct?
sure, absolutely. But the letter
Thank
was
you.
okay.
Mr. Michelini, do you have any further questions or any questions of Mr. Curry?
No.
All right, I think we're Mr. David Bailey.
Magistrate, I do have a couple questions.
Of Mr. Curry.
Excuse me?
Of Mr. Curry, you have a few questions of
Yes.
Mr. Curry?
Yes.
Okay, thank you.
Are you contending that I have misrepresented the facts and I did not deliver these documents to Gloria Moreta, as I said in my affidavit?
I'm not.
And the documents that you're contending that we did not timely file them in a manner that was acceptable to the city?
I'm not aware of anything, actually.
Okay, thank you.
I would also like to point out, Special Magistrate, if it's all right, at the end of the August 17th formal decision, it says very clearly this formal decision is subject to section 2754. If you disagree with any of the findings stated in the determination letter, you may file a petition for review pursuant to section 2761. I believe that this is the avenue that should have been taken by Mr. Accardi when the formal decision was written and published. He took exception to the fact that the zoning administrator said that it should not be used as parking, and that wasn't done in this matter. He just emailed a letter over to the city attorney's office, and that wasn't the correct method. And so in doing so, when he issued his second letter, we had to file a petition for review. And when you're the petitioner for review, the burden of proof is on you. We don't think we should have ever had the burden of proof. We feel like the city should not have accepted this letter. They should have made Mr. Riccardi go through the proper channels and file as the petitioner for review and submit the letter that way.
Understood.
So, I'm sorry, so may I just ask one?
Yes.
So, you just said a lot of things there about what happened after the issuance of the August 17th letter.
Yes.
But, and you received a copy of the email transmitting the letter, the March 8th, 2000 letter back in April of 2021.
Yes, I did.
Okay.
Sure.
And do you have any evidence to show that that didn't happen?
I'm not saying that it wasn't submitted in April. I'm saying on August 17th, the zoning administrator published and sent out an email with the formal decision. And at the end of the formal decision, it says, if you disagree with the determination letter, you can file a petition for review. And I'm contending that that's what Mr. Riccardi should have done at that point. He should have filed a petition for review because the matter was closed. And based on what it says there, I believe that he should have had the burden of proof. He should have been the petitioner for review.
And do you have?
And he wasn't. He emailed a letter to the city attorney's office, and the matter was closed at that point.
He emailed what letter? What letter did he email to the city attorney's office?
The the letter in question, the additional documentation.
And what evidence do you have that he emailed after the issuance of that August 17th letter? That he emailed something to the city attorney's office after that?
Well, that's what the zoning administrator said in the previous hearing, that after the formal decision was rendered on 8/17, he stated under oath that he received an email from the city attorney's office with this opt-out letter.
Okay, so that's what you're relying on as that.
I'm relying on the
Support for that
zoning administrator's testimony. Yes, ma'am.
Okay. Okay.
So that's the point that I'm trying to make.
Okay. No, nothing further. Thank you.
Mr. Bailey, do you have any comments?
I do. As complicated as this case may
and
seem and
I
sound,
apologize. Excuse me, Mr. Schrock. It is 9:42 a.m. I didn't want you to be impeded in your other hearing that you had this morning, so I just wanted to call your attention to the time.
I appreciate that. I also want to ensure that everyone has ample opportunity to state what they'd like to state. And Mr. Bailey, I anticipate your comments will exceed 3 or 4 minutes.
I think I can be brief and to the point.
But then I think Ms. Bailey would also like to.
I don't think we'd be in this position if the testimony by Mr. Michelini hadn't been read into the record that was not submitted as requested by you, but.
I understand entirely. I understand entirely. That's why I'd like to err on the side of affording more opportunity for you to speak as opposed to less. So I'm inclined to go ahead and resume this later today if everyone is available. Let's start with the city first as far as availability. My other hearing will likely end at noon. So I'm available from noon to 5 today.
I am available all afternoon as well. The city is available all afternoon.
I have to take a look if this room's available.
Oh, okay. Mr. Cotton's going to see if the room is, yeah, we'll get 2 floors. Double check that because he said.
I'm available up until 3 p.m.
Mr. Cadwell?
Yes, I'm available.
All right. And Mr. Bailey and Mrs. Bailey, are you available this afternoon?
Yes.
Yes.
So, Mr. Cotton,
I have a conflict from 12 to 12:30.
and
All
Mr.
right,
Cotton,
and-
is checking the availability of the room so that we can
And-
announce where we will reconvene.
Understood. And Nicholas Albergo, will you be available, sir, to come back?
I haven't heard a time yet. I can try. I'm a little aggravated by this, but I'll certainly do what I can.
I understand.
Time only takes.
I understand, sir. If you prefer to submit under the circumstances, I'll allow you to submit something in writing and provide it to the parties so that I can review your comments if you're unable to make it this afternoon. But I'm proposing a time of 1:30. Does that work for everyone?
I figured on the computer to check
Oh. Yes, that works.
Mr. Cardy, does that work for your team? 1:30?
No, I just want to make sure I can get back here, but y'all start at 1:30. If I can't get back by then, I'll get back as soon as I can. So,
Understood. And Mr. Cadwell and the
Yes.
Baileys, are you
Yeah.
available? All right.
Yes.
So we'll resume then at the same location. Does that work?
Yeah. Well, well, via Teams, yes,
Yes.
we'll resume that way.
And
Okay.
we're confirming the availability of this room. It'll either be in this room or
This is a public hearing. This is available for Teams for the hearing officer to participate via Teams.
Oh, no one else?
It's just for the hearing officer to appear via Teams.
Oh, I was gonna say, I can appear via Teams if that's of assistance.
If no one has an objection, if no one has an objection to that in light of the circumstances, I think it should be permitted for this one gentleman only. There's no objection. All right, so we'll resume at 1:30
Yeah.
in either this room or what other location potentially?
We'll have to see, Mr. Schroff, what room is available, as soon as we log off on this meeting, because the calendar is associated with this meeting.
Understood.
we'll either be in this room or we'll put a notice on the door of another location of this building.
The notice works great. Good idea.
All right.
All right, well, thank you all. We will resume at 1:30 and then Mr. David Bailey will be up.
Thank you.
All right, thank you all for your time.
Thank you.
Don't do any work, so they verify the